8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Ed Piker for Mr. Lewis.
And are you Mark Daniel Lewis?
Yes, Your Honor.
I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Mark Daniel Lewis who is placed on community supervision in 2022 CR 8453 for the offense on unlawfully carrying a weapon with a felony conviction on January 13, 2023 for a term of 10 years? Is that you?
Yes, Your Honor.
State?
Honor, violated condition number 15G on or about the 26th day of May. And Judge, I'd like to orally amend.
Oh, just one moment. Excuse me. Could you, if you all could move to the other end. Okay. All right. Are we proceeding on the motion as presented, State?
Judge, we'd like to orally amend. I've conferred with defense counsel. We'd like to orally amend the years.
Hold up. Did you catch that? The state just corrected the year from 2026 to 2023. That might sound minor, but in court, dates are oxygen. A wrong year can sink a revocation. The judge even calls it a substantive change, meaning it actually affects the legal footing of the motion. Now here is the key question for you. If the defense had objected and asked for 10 extra days to prepare, would this entire hearing have been delayed? Small detail, big leverage. Courtrooms run on precision.
Did then and there fail to comply with the rules, regulations, or instructions?
Excuse me, just one moment. Were you changing that date?
Yes, Judge, to 26th day of May, 2023.
Okay. All right. Thank you. Sorry about that.
Sorry. In Rusk County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Treatment Facility, in that the defendant was behaviorally discharged from the East Texas State ISF unit in Henderson, Texas, in violation of condition number 15G.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation 15G, the court could find it true, grant the motion, sentence you to 6 years in prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of 15G?
He just pled true knowing he could get 6 years in prison. That is not a casual yes. When someone admits a probation violation like this, they are basically handing the judge full sentencing power. No trial, no witnesses, just judicial discretion. So now the tension shifts. Will the court hammer down or look for rehabilitation? Drop your prediction right now. Prison time or second chance?
I could ever tell you.
All right, Mr. Piker, what are you requesting?
I am requesting that the court consider keeping him on probation, not revoke him, and move him out of, don't revoke him, don't send him back to that facility and send him to lifetime recovery. We've looked into it. It's a 3-month residential. He's motivated. Actually, it was his suggestion that if that was possible to get him out of there, he wants to help. He wants to get off the drugs, but he can't do it where he's at.
Okay.
And he is going to explain that to you better than I can.
All right, Ms. Abrams.
I apologize. I cannot hear.
On this case, it is Mark Daniel Lewis. There was an incident at Henderson, and he wants to, his attorney is suggesting that he be placed in inpatient at lifetime recovery.
Your Honor, probation would not have any objection.
Okay. And so that I will know, what is the issue with that facility? We'll say allegedly.
Would you like to hear it from me or from Mr. Lewis?
Either one.
Mr. Lewis can explain it better than I, but I will tell you that he was in a gang. He was in a gang when he got there. He wanted out of the gang. He told him he wanted out of the gang. His life was threatened. His well-being was threatened. And quite honestly, from what he tells me, there was so much drug usage there and fight night that it was not conducive to getting better. It made it worse.
All right. And this is at the facility in Henderson, Texas?
Yes, ma'am. He will swear, he will tell you that under oath.
Oh, no, I'm going to make sure that the facility at Henderson, Texas, that we do, that a spot check is done, random, so I can figure out what's going there because.
Now this is interesting. The judge is not just reacting. She is signaling oversight. When she says she wants a random spot check, that is judicial muscle flexing in a very calm way. If what he is describing is true, drugs and organized fight nights inside a treatment facility, that is explosive. Treatment centers are supposed to reduce recidivism, not rehearse it. So, here is the bigger question. If facilities meant for rehabilitation are compromised, how does that affect future cases? Because judges rely on these programs as alternatives to prison.
So I chose to help. And whenever I was finally transported to Henderson, Texas, I threw myself into the program and I started learning about thinking errors. I started learning all the aspects I needed to learn for my first track, which was cognitive intervention. And I had a very successful 45-day call. But during that time, I made the decision to step away from the gang affiliation that I was affiliated with. And I made it known that they were doing fight nights. There were people out there still smoking K2.
Fight nights.
Yeah, it was disrupted. The counselors would come in and they would read from a piece of paper for an hour and they would leave until the next day. And it was back to the same stuff. And I made it known that I didn't want no part of any of that anymore. I was trying to get back to my daughter. I let everybody know, like I was back in my Bible. I was trying to get myself right. And a lot of people took that offensive and they threatened me and they were trying to jump me. And thankfully the guard was able to see that something was going on and they pulled me out of the dorm that I was in and they placed me in a single man cell in restrictive housing. And when they came, they were like, they wanted to send me back to that environment. And I wasn't trying to go back to that environment because of the threat. And they said that by refusing that environment, I was refusing the program. And I knew that I would have.
That right there is the emotional hinge of this entire hearing. He walked away from gang affiliation, inside a controlled environment. That is not small. Whether you believe him or not, stepping away from a gang can carry real consequences. And legally speaking, refusing to return to a dorm because of threats can technically count as noncompliance, even if the motivation is survival. This is where law and lived reality collide. Let me ask you this. Should refusal under threat automatically equal violation?
Thank you, Your Honor.
You didn't get any more tattoos while you were there, did
No,
you?
thankfully not.
Okay.
Thankfully not.
And he's not from Indiana.
Okay.
Okay.
All right.
All right,
Thank
thank you, Your
you.
Honor.
Thank you for letting me know.
Thank you. Thank you.
All right, counsel, have you received all the discovery?
Not yet, Your Honor. You're getting it to me. We should have it soon.
Well, there's a lot of discovery. I haven't been able to confirm that we have the CPS records.
Okay.
Look into that.
Yeah, that's all.
All right,
You
Miss.
give me one, I could probably have it all done by then, Judge.
All right, Ms. Ferguson, on this case, because I'm being told it's a lot of records in this, I see this is an SBI omission. So, Ms. Ferguson, on this case, can you give me a 45-day reset, please?
Good judge.
All right, we'll be back on August 31st. And Ms. Elizondo, this is for me to make sure that your attorney has all the discovery. Do you have any questions about anything? All right, thank you.
Thank you, Jury. Would be excused.
Yes. Umberto, it's always good seeing you.
Good to see you, Judge.
Yeah. All right, the court is calling 2023 CR 3412B, State of Texas versus Mr. Sierra. How do you pronounce your first name? Eliza. State of Texas versus Eliza Sierra. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Umberto Saldana for Mr. Sierra.
And are you Mr. Sierra?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sierra, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive.
State, are you proceeding on the indictment as presented
Yes, Your Honor.
on both counts?
Yes, sir. Well, I believe the first count is with consent to deliver and the second count is just mere possession. So we're proceeding for the judge.
All right, state, are you proceeding on count one, waiving count two?
Yes, Judge.
Any objection?
No objection.
All right, Mr. Sierra, I'm showing you what's entitled court's admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand your charge of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Sierra, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on count 1. They're asking that your punishment be assessed at 8 years in the prison. There's a $500 fine. State recommends community supervision. There's to be judgment satisfied entered in county court for cause number 699061. You are to agree to have the weapon destroyed. And there's to be no possession of firearms while on community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 8 years and there'll be a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, I submit State's Exhibit 1 in the attachments.
No.
Any
objection.
objections?
No.
All right, state, you may continue to confer.
Thank you.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, he is gonna work once out there. He says that he is looking to get this all behind him. And he is asking for intensive outpatient treatment if possible, because he works so many hours. I know that the TAP will show that up, Your Honor. I just wanted to add that.
All right. So what do you do other than have cocaine and meth?
I do framing and construction cleaning,
Mhm.
and I have a business, a clothing business that I'm trying to get off the ground.
Mhm.
And
And you're just doing drugs on the side, part-time?
no, it's just being foolish, Your Honor.
How old are you?
I'm 31.
I mean, how many years are we going to take this foolishness with us?
That's just and everything happens for a reason. And being here incarcerated, you know, I've never really read the Bible and stuff like that. And I found that light in me now, you know, and I wake up more happy and everything now, you know. I'm ready to just take my life, you know, serious.
Yeah, what's your favorite verse in the Bible?
The Lord is my shepherd.
Oh, okay. Yeah, what verse is that?
It's Matthew.
What verse is that?
That's Psalms 23.
Okay.
This moment shifted the temperature of the room. The judge tested him gently, not to embarrass him, but to measure authenticity. In plea hearings, credibility matters. When someone claims transformation, courts look for consistency. Then things unravel slightly when confusion starts about who was in the car. That contradiction is why the judge orders a PSI and a treatment assessment. Translation: she needs more data before sentencing. So now I want your take. Is this a man at the beginning of real change, or someone still editing the story as he goes?
Emily Colleen,
What were you doing with Samantha then?
that's my cousin.
So you and Samantha Servin were out with
No,
drugs?
I wasn't out with,
I'm sorry, what?
I wasn't out with nobody.
What? What is he saying?
He's saying that he was not present with anybody at the time of the arrest.
No, you were in the vehicle. What is he talking about?
That is his cousin that is mentioned in there.
All right, is something wrong with him?
No, Your Honor, I believe that that's the only aspect that he sort of maintained was not accurate on the report. But he says everything else is accurate.
So you were not in the vehicle?
I was in the vehicle, but there's nobody with me.
Oh, so you're saying Samantha wasn't in the car with you?
I was by myself in that car.
No, they have S1 and S2.
Your Honor,
It says, based on my observations during my surveillance of the listed location and results of the traffic stop, we were able to detain S2, who was the subject of our investigations. We encountered S2's small children occupying several bedrooms of the home. Okay.
I was just drunk, I guess.
No problem. I understand. I'm going to need a PSI report on this. Ms. Ferguson, when can we come back? I need a TAP evaluation.
and I know it's a little unorthodox to ask, but would the defendant be eligible for a clear bond under the circumstances that he's already pled?
No, we'll see about a TAP evaluation, and maybe we can get the TAP evaluation done quickly. Will it take long to have a TAP evaluation? Okay. Oh, thank you. So, Ms. Ferguson, can we recall this back in 2 weeks?
Yes, ma'am.
And I'm just asking for a TAP evaluation so I can get an idea of what's going on.
Yes, Your Honor.
You can have him come back on July 17th.
All right, so we're going to be back on July 17th. Mr. Sierra, you need to be very honest with what you tell them in the TAP evaluation, because there's something going on here I'm not able to figure out because I don't have enough information yet. So make sure you're honest with them, okay?
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
Thank you.